data privacy laws, inadequate transparency in surveillance, and unlawful intervention, amongst others. As an organization, there are two key areas of interest to us. They are freedom of information online in Section 14 and e-governance in Section 17, as contained in the provisions of the bill. Section 14, subsection 2 states, the existing obligation on public bodies to share all information produced with the support of public funds in terms of subsection 1, subject only to clearly defined rules set out in law as established by the Declaration of Principles of Freedom of Expression in Africa, shall extend to the proactive release of such information on the World Wide Web in openly licensed, freely releasable formats. For EIE, this is a follow-up to the Freedom of Information Act 2011 and a step in the right direction to ensure that democratic benefits are duly delivered to the electorate by their representatives. We hold the public service virtue of accountability and probity very high. To better achieve results, we understand the need to deploy the tools of technology, and the internet is a tool of worth in this regard. We believe that freedom of information online will help gear citizens towards a more participatory governance and the government a more responsive entity. In this regard, we implore this Honourable House to allow this section, including those with ancillary provisions in the bill, to become law. On e-governance, Section 17, subsection 1 of the bill captures our thoughts on running institutions that are transparent and accountable. In the bill, it states, an open, modernized e-governance system enabled by free-flow access to information and the manner which citizens and businesses interact with government representatives and other agents of the state shall be pursued vigorously. This goes hand in hand with implementing a holistic adoption of freedom of information, whether offline or online. In order for the government to respond to requests for information online, it must not only have an online presence, but also an effective way of disseminating facts. The business of government in the days of rapid innovations and economic growth through internet commerce must fall in line by adopting a viral e-governance system that seamlessly digitizes all of government's activities. EIE Nigeria has continually championed a healthy government-citizen relationship to deliver good governance and, by extension, economic development. We know for a fact that enduring republics are built on the strength of ideas that stand the test of time, and government is willing to cooperate with these innovative ideas. One of such ideas that are consciously and deliberately worked out is the Digital Rights and Freedom Bill, HB 490. We are confident in the ability of this House to see that this bill is passed to law, and also that the beauty of democracy, which is often based on the respect for human rights, are protected by those legitimately appointed to do so. Thank you very much.
Impact on Nigerians actually has the support of the association. Now, we feel that there's some kind of duplication in so many areas. Those silent areas include what we call subscriber information or what we call citizens information. Now, on citizens information, this is very well protected, even as it is today. Nobody can access somebody's information except through, through the law or by himself. Now, there are two ways information of citizens are secured in our ecosystem. Now, as operators, a subscriber who is a citizen has the right to request for information regarding himself. That is one aspect. The other aspect is by security agencies. Now, that brings us to the question of lawful intercept, which is what I think Madam, you should look at very carefully. The provision on lawful intercept. If you look at the Constitution of Nigeria, lawful intercept was made as, standing on top of all other rights. In other words, it's a matter of national security. So when the national security issue is involved, you have to bow to lawful intercept. But that is the constitution as it is today. It has not changed. And based on that issue, even us operators have done so much in terms of implementation and so on regarding lawful intercept. Now, are we going to ask this law to change as it is today? As it is today, and rightly as you provided, I see that there's a place for warrants from the court of law and so on. That is also provided for today. So while you're looking at the issue of lawful intercept, you should also be looking at the Cybercrime Prohibition Prevention Act, which is also in force today. For that act covers almost all the things you have said, surveillance, even provides for part of lawful intercept, and all sorts of things. The other area that is critical for us is storage of information. We note that in the bill, the period of time which is required for information to be stored is like 100 years or something like that. Maybe the makers of the bill did not think of the cost of storing information. Information storage is not just about keeping data. It involves costs. Those costs should also be looked at. The Cybercrime Act provides for 2 years. Before we came to that 2 years, there has been an ongoing consultation with the industry, with all stakeholders, before we came to 2 years, taking into consideration what it will cost to keep that information. Because between you and me, government cannot keep that information as it is today. Information regarding subscribers, even though there is NIMSI today, lies with subscribers. So please look at the Cybercrime Act critically so that you can compare it with what we're doing. Look at issues relating to lawful intercept, storage of information. We think that 25 years without 100 years is like, it's unattainable. So in summary, we want the law to be passed, but please, if we have to pass it, we need to scrutinize it carefully and be able to expunge all those areas where there are conflicts. Also look at the issue of lawful intercept, because I don't see somebody from ONSA here, and maybe they should have been made stakeholders to this gathering, because you may think you have gone ahead, at some point they will stop you. So you need to take that into consideration. Thank you.
This bill very fascinating. And the reason that I find it fascinating is the trajectory of the bill. The bill is the product of very effective partnership between the National Assembly and citizens. And for me, it exemplifies what we should have in a functional democracy. So I want to applaud the way that this has gone and to hold it up as a standard for how we should try to solve problems that we have in our society. And so I congratulate the sponsor of this bill, as well as other members of the committee, especially the chairman, for the way that you have been intentional and deliberate in working with citizens toward codifying the rights that are necessary for life in the 21st century. I also would like to state clearly that one of the things that we know is that Africa missed the agrarian revolution. Africa missed the industrial revolution. But one revolution that Africa has led is the information technology revolution. Therefore, understanding the possibilities that are contained in this particular revolution is an indication that we are in tandem with the rest of the world. And being in tandem with the rest of the world, especially as regards digital rights and freedom, is to go beyond mere aspiration and policy to the place of codification. Because with codification of those rights, what we do is that we're more transparent in terms of the balance between right and responsibility. And that's what I particularly like about the fact that this bill seeks to establish that indeed every Nigerian has the right to digital services and to the freedom that comes with it. Number 2 point that I'd like to raise in this regard is that when the United Nations, through the Universal Declaration of Human Rights in 1948, talked about the universality of human rights, it didn't probably imagine the way that technology was going to be ubiquitous. So we now are faced with the ubiquitous technology and the fact that we cannot possibly lead our lives without technology. Now, considering that the Universal Human Rights Declaration states that rights are indivisible and inalienable, it means that no matter what it might be and where I might be or you might be, your rights are inalienable, your rights are indivisible. And so what it means is that whether we're spending our lives physically on the terrestrial context, or we're spending our lives literally within the cyber world, our rights remain our rights. So rights that are defended offline must be defended online. That's the spirit of this legislation. And I need us to understand that, because if people don't understand the general principle behind this kind of a legislation, they might actually think they're trying to do citizens a favor. No, that's not what's going on. What's going on here is to ensure that nobody maltreats citizens or takes away any aspect of their rights simply because those rights were exercised, not physically, but online. That's what we are, trying to defend as far as this proposed bill is concerned. And then to also state that number 3 point is that this bill is coming at a time where in 2016 we probably have data penetration rate of about 42% or maybe by now 46%. So we're still a long way to go, especially the divide between the urban and the rural dwellers. And yet we know that once that divide is breached, that it adds at least 2 digits of economic growth to development. That's significant. So anyone thinking of this bill must think of this bill in terms of what it carries in its womb for accelerating economic development, economic growth, so that we don't sort of think, oh, there are so many things that go wrong online, therefore we don't need this bill. No, we must recognize that there are no perfect solutions. And balancing life is about trade-offs, right? We're constantly making trade-offs between the good and the bad. And one thing is clear, that with a legislation that underpins the digital rights and freedom, what we do is that we clarify those aspects that worry us in the most transparent way, so that everyone is clear as to what the remits of those aspects. So the cybercrime, for example, has codified a number of issues. What needs to happen is that we must find a way to build harmony between this bill, every other bill that's in the offing, that seeks to solve some of the challenges that were raised by NCC as well as NITDA. We need to find a place of harmony, and then to find a way to ensure that the provisions, especially on those aspects of data privacy, I think Section 11 that deals with data privacy, on aspects of Section 10 that deal with surveillance and lawful interception. Those aspects, those elements are borderline difficult areas, because these are the dangerous terrains. And I heard the representative of Airtel say something about the high order of the lawful interception provision. But I need to let him know that that high order was given on the basis of our militarization. We were coming out of military rule. The military wrote the Constitution. They had this mindset of, national security as being anything that is critical of the nation state. We are in a democracy now, and the democracy functions on the basis of the power of the citizens. And so, Mr. Chairman, I want to state clearly that while we worry about some of these dimensions to existing laws and even provision of the Constitution, we must lead the way in showing clearly that we're dealing here with information technology, and that with information technology, you either are ahead of the curve or you are gone. We don't want to be gone as a country. Therefore, we must be ahead of the curve in the way that we prepare our citizens and amplify their capability to function in today's world. Why must they function well in today's world? And why is the right to the internet and everything that has to do with digital services necessary? It is because the competition that our citizens face today is no longer amongst ourselves. The competition that we face today is not even with West Africans, is not with Africans, is not with the developing world. Our competition is the world. If our competition is the world, we cannot allow our own particular experiences to reduce the extent of our ambition at ensuring that productivity of our citizens drive the basis of our economic growth and development. My final point, Mr. Chair of the committee, is to say that the problems of bad, or maybe I should say, rascality in the use of rights of this kind can be contained by ensuring that we would begin a proper education or sensitization of our judiciary to the necessity to show examples of how libelous matters are treated in our democracy. Because we don't have a record of libelous, judicious, and very speedy judicial proceedings on libel. So people have decided that they can libel anybody, and there are no consequences to it. So don't look at this as, don't do this in silos. This kind of a legislation cannot be done as a silo. We need to recognize that it can be a trigger for improving certain aspects of existing legislation where we have not particularly done well. And then, Mr. Chairman, one of the things we found is that a lot of the times countries have gotten the message that moving from policy to law is a great way of building systems, structures, and institutions in predictable patterns. However, what they have not learned is that any good law that sits on the shelf and does not have any kind of execution is as good as not having the law. And so we should immediately, as we're thinking of the passage of this law, think of the kind of expertise that even the National Human Rights Commission would now have to possess in order to be of any effective, to be an effective implementer of the rights that are being given. Because this is it's not really an expansion of their right, but it is an admission of the fact that their right, the mandates they have now go beyond physical circumstances of the defense of the human rights of citizens. Let me tell you again that I am really fascinated by the work that you've done, and I want to very much applaud it, and to say that we as members of the citizens movement, I got your letter just a couple of days ago, and considering the kind of schedule that I run, I still said that I'm actually leaving from this podium to travel, but I said I must come because I wanted to make sure that I demonstrated that I do welcome collaborations that lead to our being able to solve problems.